Hi, everyone. Sam Silverman, Managing Partner of EB-5AN. Thank you for taking time to join us on today's webinar. Today, we're going to be speaking about EB-5 investment source of funds, best practices for H-1B visa holders. The slides are available. If you'd like to get a copy of the slides, you can email us at info@eb5an.com. And we're happy to provide a copy of the slides from this webinar. Here's a quick overview of the different sections that we're going to cover today. We'll start with a little bit of an introduction. We'll introduce our guest panelists. We'll talk about concurrent filing. We'll talk about source of funds considerations specifically for H-1B holders. And then we'll get into a case study of a real EB-5 investor's petition and what that looked like with exhibits. And then we'll spend a few minutes at the end speaking about currently available urban and rural TEA investment projects as well. So a little bit about EB-5AN. We're a national EB-5 investment fund manager, regional center operator. We cover all 48 continental United States, and we've done a significant amount of EB-5 projects over the last 11 years or so. This is another map showing where many of our investors have come from over the years, more than 60 different countries to date. And our regional center EB-5 licenses allow us to do EB-5 projects across the country. I'm Sam Silverman. A little bit more about my background bios there on the left side. And my partner Mike, who's not with us today. And then now I'll take a few minutes to introduce our guest panelist, Dennis Tristani, an established EB-5 immigration attorney, also fellow Yale graduate, who I'm very excited to have with us today. And I'll let Dennis jump in and share a little bit about his bio, background, experience, and what he's seeing in the EB-5 space today with all these new advantageous reforms that have taken place recently.
Thanks, Sam. It's a pleasure to be here, everyone. Dennis Tristani, based out of Washington, D.C. I've been an immigration attorney since 2012. I've been in the EB-5 space since 2013. I've traveled all over the world doing EB-5 conferences, seminars, meetings. Over the last 10 years, filed a few thousand applications in that same time frame. I started my own law firm 3 years ago. I do the same work I've always done, so lots of EB-5, both direct and regional center based, and I'm a business immigration attorney by practice, so many of my clients are here in the US on a variety of temporary and or work-based green cards. It's an interesting time for EB-5 and definitely a good one. The reforms that the RIA brought through a few years ago have not only strengthened the program, but have provided significant opportunities for new investors to not only pursue a green card in a much quicker fashion than they could before, but also file an I-45 petition application concurrently. And so all in all, I think it's an exciting time for EB-5. I think it's a good time to be looking at the program if it's a good fit for you. And my bio's online. I don't want to bore you with that, but it's really great to be here today. And thanks again, Sam, for inviting me.
Thank you, Dennis. All right, so one of the first things I want to talk about, since it's new and has really changed the nature of EB-5 for a lot of potential investors out there, is concurrent filing. So, Dennis, can you give us some background? What is concurrent filing? Why does it matter for EB-5 investors, and who specifically does it matter for, and what's the benefit?
Yeah, so generally speaking, a concurrent filing is when you file an underlying immigrant petition together with Form I-45 to adjust status, which is essentially a mechanism to change one's underlying non-immigrant or temporary status in the US to green card. It's always been available for individuals filing a family-based petition on Form I-130, an employment-based petition on Form I-140, but only until recently has it been available for individuals filing an EB-5 petition on Form I-526. Prior to the RIA being enacted, that wasn't that wasn't an opportunity. So EB-5 investors were forced to file their I-526 petition, wait for a positive adjudication and approval, and then file Form I-45 to adjust status, which is an inherent disadvantage in terms of timing. There's a significant benefit to filing Form I-45 if you're an individual present in the U.S. in lawful status, whether that's an H-1B status, an L1 status, an F1 student status, or even in certain circumstances in B1, B2 visitor status. You take advantage of the inherent processing time for the I-526 petition, and you allow your I-45 application to not only be receipted and accepted, but to gain processing time to sort of take a step towards adjudication. The inherent benefit there is once the I-526 petition is approved, your I-45 is going to have been pending for months or even years. And so it'll be in a position where it can be approved shortly after, which will result in the issuance of the temporary green card. A few other ancillary benefits that I think are particularly important, I'm not sure if they're on another slide, but I'll touch on them briefly, is that any applicant for adjustment of status can also file Form I-765, which is an application for employment authorization, as well as Form I-131, which is an application for advanced parole or other travel benefits. And in the EB-5 context for an adjustment of status applicant, it's for an advanced parole travel document. These are ancillary applications. For many individuals who are already in H-1B status, for example, and have a valid visa to travel, they can be considered backup work documents or travel documents. But for individuals who perhaps are in F1 student status and are running out of, of OPT or STEM OPT, someone who may have entered the U.S. as a tourist and then later decide to pursue EB-5, the adjustment of status process allows you to stay in the U.S. lawfully in the event that your underlying status expires, okay, based on a period of authorized stay based on the pending 45. And if you're in that situation, you don't have work authorization or travel authorization because your visa may have expired, you can use the EAD and you can use that advanced parole travel document once they've been issued. So for many individuals who perhaps are running out of status or don't have status that allows them to work in the United States, the I-45 adjustment of status process is a significant benefit. I can't stress that enough. Moreover, USCIS's processing times have significantly improved in terms of the issuance of the EAD and the advanced parole document, which fortunately are being issued for 5 years on one combo card at present. It's not always the case, but that's typically what we're seeing. And they're being issued in approximately 90 days. There's been a brief slowdown in June, but for a vast majority of my clients, they're still getting them in 90 days. I think one other thing I would mention is adjustment of status is simple. It allows you to remain in the United States. You don't have to travel abroad for a consular interview. Almost a vast majority of EB-5 applicants have their interviews waived. I haven't seen an EB-5 applicant have a visa interview in the United States if they're pursuing adjustment of status. It's typically only something that's done when you consular process and you receive your green card in the mail. In that sense, it's a significant benefit for anyone who's in the United States, who has valid temporary visa status, and is looking to pursue the EB-5 process while they're still working here or studying here.
Got it. Okay. All right. So now that we've covered that, which is really important for those investors already in the United States on those visa types that we discussed, let's shift over to the main topic, which is source of funds considerations for H-1B visa holders. And I think just high level, let's start with just what is source of funds? Why is it relevant? Why do investors have to go through this exercise? And what's the purpose of this exercise from the government's perspective? And then we'll jump into, okay, how do we accomplish it?
Yeah, that's a good question. The EB-5 program was, started about 35 years ago, and source of funds rules and regulations have been around since then. And the goal of the EB-5 program generally is to stimulate the economy and to create employment, to create jobs for qualified U.S. workers. Because the process involves an investment from an individual, there's obviously the possibility that that individual could have obtained funds illegally, whether it be through any type of activity that could be deemed illegal in his or her country or in the United States. So source of funds rules are designed to prevent that. The onus, the burden, is on the EB-5 investor to provide documents with the I-526 filing that prove two things, that prove the lawful source, so the origin of the funds you're investing, and the lawful path, so a clear path of funds from origin, if possible, to investment. Okay, and so generally speaking, the government sort of they peel back an onion, they peel back a fruit in a sense, and they look at your investment from the moment you've wired funds to the project of your choosing with the regional center that's sponsoring that project, and they'll go backwards. They'll look at where the funds were in your bank account prior to the wire and what those funds consisted of. And so generally speaking, the EB-5 investor has to have documents that are not only clear but are accurate and straightforward, that allow the adjudicator to approve the case and to feel comfortable with the origin of the funds. Okay, the standard of evidence isn't clear and convincing. It isn't beyond a reasonable doubt. It's a preponderance of the evidence standard, which is 51%. But in practice, I think most adjudicators don't consider that correctly, and they can get very strict and they can be very specific with the documents they ask for and their adjudication. So I advise my clients we try to paper the case as strongly as possible, as accurately as possible, and as straightforward as possible. These adjudicators don't have a lot of time to review cases. They're overworked, and so presenting things in a detailed yet straightforward and concise fashion is definitely recommended.
All right, let's jump into the four major sources, and then we can kind of spend a little bit more time on each of them as we go through. Okay, so to start out, I guess just give a quick kind of 1 minute on each of the major four sources, and then we'll really dive in and spend more time on each one individually.
Yeah, absolutely. So the four sort of sources we see on the screen are far and away, I'd say, some of the most common sources of funds used by any EB-5 investor, both past and current. Ordinary income, also known as earned income, is income that's either earned by the investor or his or her spouse. Typically, in most scenarios, these are funds that are provided to you as salary by your employer, and or if you're in a situation where you or your spouse owns your own business or owns multiple businesses. I think it's an important thing to mention, especially in the H-1B context, that many families have one individual who has an H-1B salaried position. So, earned income is going to be salary, bonus, perhaps stock incentives, RSUs that are given to them as compensation from their employer. And the other spouse may have an H-4 EAD. So they have an open work permit, which will allow them to perhaps be self-employed, perhaps to have a salaried position and or run a family business. And so I see this very frequently with many of my clients who are married and are H-1B status, that you'll have a variety of sort of ordinary earned income, whether it be salaried or from a sole proprietorship or your own company. Capital gains, also obviously incredibly common. Generally speaking, when you sell an asset or you have a gain on an asset, that's going to be considered a capital gain. So you're going to have it's very common to sell an asset and use the proceeds of the sale for EB-5. Now, whether that's selling stock, selling another currency, whether that's selling cryptocurrency, whether that's selling a hard asset, an immovable property, perhaps your car, et cetera, et cetera. There are numerous considerations to consider when using the proceeds of the sale of an asset in terms of how one acquired that asset in the first place, whether or not the sale of that asset had a capital gains tax based on where the individual lives in the taxation scheme in that country. And then obviously the flow of funds from the sale of the asset to the individual's bank account, and if anything happened in between. Okay, I typically advise a lot of my clients to set up a separate bank account if you're going to pursue EB-5. And once you have an actionable sale or you have proceeds that you're going to use, to isolate them in a separate bank account to avoid commingling of funds. Okay, I think we can. The third topic is also very common. Gift funds, inheritance from family or friends. The way I think of this is, imagine the funds were already yours to begin with. Okay, and then the question is, how did you obtain the funds? So the same type of documentation I would typically ask my client for, if the money was already theirs, if they've earned it, we'd like to reproduce those documents as best as possible for the loaner or the gifter of the funds. There's special considerations, obviously, for inherited property, for inherited jewelry, for funds that have passed down through generations. Document, restrictions are definitely going to be something that comes up if funds have sort of, passed through generations and have been used differently over time. So there's certain types of documents we'll definitely want to produce, whether it's a sworn affidavit or declaration, and then we'll try to bolster those subjective documents with more objective documentation, such as bank statements, such as probate records, tax records, essentially whatever objective documents exist. And finally, loans. Loans are incredibly common now, and especially since the precedent Zhang decision. I think we're almost 4 years past that decision, which essentially stated that cash is cash and that unsecured loans are acceptable as a source of funds, meaning your loan if you use proceeds from a loan for EB-5, typically before this decision, they had to be collateralized by your own assets. Okay, that's not the case now. Unsecured loans are perfectly fine so long as the loan document is acceptable, so long as there's no restrictions on the use of funds. And in the case of a loan that's not from an institution or a large lending company, that the funds were lawfully sourced. We're seeing numerous approvals for cases that have unsecured loans as the entire and or part of the source of funds. So, because of this decision, in certain circumstances, an unsecured loan may be more favorable to a secured loan because USCIS still can inquire into how the collateral was obtained in the first place. Obviously, this will depend on different situations, and collateralized loans may be better for certain individuals based on interest rates and the availability of unsecured loans. But I think it's a very, very common source of funds to use at this point, especially because unsecured loans are now acceptable.
Yep, perfect. Okay, so now we're going to spend a few minutes and kind of really drill down into the nuances of each of these individual four buckets. So starting, we'll do best practices first, and then a little bit on common problems. So I guess, Dennis, we can kind of plan to split the time across these two slides for each of the four topics.
Perfect. Yeah, sure. Perfect. That works. So your earned income, generally speaking, the government will want to prove you're employed. Okay, so what that means is, depending on how much of your earned income you're using and what employers that may have come from, if you've recently started if you started working at Google and previous to that you were with Amazon, we're going to want to document your employment at both of those companies. Okay, so that's generally an employment contract, some type of confirmation letter that, you may or may not have used for an H-1B visa or your I-140 process in the past, and pay stubs. Either work. Typically, I'll include all of them. Generally speaking, if only some are available, pay stubs in and of themselves prove your employment. That being said, most individuals will be able to have will have some type of formal offer letter or confirmation letter that will confirm your employment. For most of my clients that are using earned salary income and or investment income that's based on the use of their earned income, I approach these cases in sort of a pattern scenario where, if you've earned income lawfully over the last 3 or 4 years, or 5 years, for example, to make things simple, we could include 60 bank statements, right? We could include, hundreds of pay stubs. And while some cases may merit that, depending on, specific factors, generally speaking, if you've had straightforward employment, you've been earning regularly, you've been saving regularly, you've been investing regularly, and you have a straightforward pattern of doing so, I'll have most of my clients provide sample bank statements for periods of time, sample pay stubs for that period of time. And if you've been routinely investing in different brokerage accounts, for example, whether it's Robinhood or Schwab or wherever, we'll include sample brokerage statements, and we'll confirm a distinguishable and a clear pattern of earning income regularly and investing income regularly. Where we'll get really specific is, again, right at the end, where we have large transactions, whether it's the sale of securities that you've been investing in for some time, and or bonuses that have come in recently. We'll want to highlight larger amounts that are clearly resulting in the pooling of funds that you're using for your investment. But again, for income that's going back 5, 6, 7 years, we want a significant pattern. Okay, we want a strong pattern of income. That being said, every case is different. So if you have other funds, for example, that you've been gifted, that you've been loaned, and we'll touch on that soon, that are commingling in with these, with this earned income into the same account, we're going to want to highlight those transactions, because again, USCIS has the right to ask for all the bank statements. And if there are large sums of funds that are coming in that aren't related to your earned income, we're going to want to identify them. When you're self-employed, things are a little different, right? You've started a company, perhaps you or your spouse has an EAD that's an open work permit, and you have a successful consulting business or an IT business, for example. The government's concerned with a few things here. Generally speaking, they're concerned with, how did you start the business? For a lot of my clients, there weren't significant startup costs. They formed the LLC, and they maybe had a few contracts with vendors and or service providers, and they went to work. If there was significant startup capital to launch the business, then the government does have the right to inquire as to where you obtain the funds to start the business. Okay, so that's something we'll want to identify early on. Second, ownership of the business. So we need simple formation documents, whether it's an LLC or an S corp or a C corp, to prove the individual's ownership of the company. Second, the government's concerned with the lawful operations of that company. Has it been paying its taxes? Okay, has it been filing relevant documents with the state secretary of state to operate legally? So again, formation documents, taxation documents, and then typically I like to include documents such as invoices, contracts, purchase orders, bank statements. Again, we don't need thousands and thousands of pages, but good sample documents, maybe a few per year, that confirm the lawful operation of this business. And again, we're building a case that the government can feel comfortable with. If we file something that's very bare bones and doesn't have good documents to prove what the company does, the government can ask for it. So, if it's a lawfully operating company, we want to prove that. And then finally, the government's going to be concerned if you're paying yourself, if it's a pass-through entity, or if you pay yourself dividends or profits, we need to confirm that the funds are actually coming from your company. Okay, so that's bank statements, that's perhaps profit distributions or dividend statements, depending how your company's operated, if there's other partners or investors that have to sign off on those documents. For a lot of people, if you're self-employed, Those are just bank statements proving that you've transferred funds from a business account to your personal account and that you filed taxes properly, okay? Finally, I think it's really important to point out is if you paid yourself $100,000 from your business bank account and then a month passed and then you filed for EB-5, we want to know where those funds went in the interim. Did they sit in the bank account? Were other funds commingled with them? Did you invest those funds? Did you lend them to someone? And so again, we always work backwards. And so the best practices is to isolate funds as soon as you can. And then if you've used funds, whether it be from your salary or from your own business, after you've paid them to yourself or after you've received them, we want to document as best as possible where they went, especially if they're larger amounts.
All right, great. Let's talk about some of the common problems that you've seen, after working on thousands of applications. What are some of the issues that you try to spot and resolve before any of these questions get called out by USCIS?
Yeah, absolutely. I think it's better to ask hard questions, or difficult questions before we file. I try to be really straightforward with my clients, and I've done this long enough where I know what USCIS wants to see, I know what they used to want to see, and I know what they want to see currently. Adjudication trends have changed, policies have changed. We can just sort of go one by one here. Translations are straightforward. Any document that's not in English has to be translated. Whether you're using a formal translation company or it's someone that's simply fluent in the foreign language, that also works. Generally speaking, if we're talking about bank statements, financial records, tax records, I'd recommend having them professionally translated. Normally, I'll work with my clients to sort of confirm what specific sets of documents we want to use, especially if the documents aren't in English, because we don't, there's no need to translate, 1,000 pages of documents if the specific documents or pages we need only, add up to 100 pages, for example. But again, everything in a foreign language has to be in English, okay? And they will flag 1 page or 50 pages that aren't translated. And so again, it's an expense, but it's a necessary one. Taxation is incredibly important, and again, especially if funds are coming from abroad, tax regimes differ from country to country. There's numerous countries in the Middle East, for example, where certain taxes aren't applicable. In India, for example, there's an incredibly complex tax regime for gifts, for inheritance, and/or property and other sources of funds. So the government has the right to ask whether you've paid taxes on your income, on the sale of assets. Nowadays, the RIA, has a strict requirement that the investor has to provide 7 years of tax returns, which is, the number that was essentially made up that we have to comply with, even if you've received a bonus from your employer for $1 million last year. We still need 7 years of tax returns, okay? And so that's if you've been working in the US and or any other country, okay? Generally speaking, what the government will look at with tax returns is to confirm, that numbers are adding up, that taxes have been paid on any of the income that you're using for EB-5. It's also not common for the government to make mistakes with foreign tax regimes, to ask for tax documents that may not be relevant. Typically, if I can assume that may be an issue, we'll address it in a cover letter. We may provide documents from the relevant tax authority or even a letter from an accountant in the foreign country to confirm what taxes had to be paid and that they weren't paid and that certain taxes aren't applicable in that country. Tracing is a huge issue again, and again, the government works backwards. So again, they're gonna see $800,000 being wired to the NCE's escrow account, and they're going to take a step back and ask, what was the source of funds in the account immediately prior to that wire? Okay, and what's very common is that you have an influx of funds coming from brokerage accounts, perhaps coming from a HELOC, perhaps coming from a gift from family, and then we work backwards from there. Okay, and so being very specific with final transactions is incredibly important. Okay, and I say that because the government will look at the wire transfer receipts, then they'll look at bank statements, and they'll start working backwards from there. Okay, commingling of funds is also an issue. If you have large transactions that have come in to your bank account after deposits of funds that we've already sourced, the government will ask about them. If someone lent you $25,000, if you won money, at the casino and you deposited cash, for example, if you hit the lotto, if you have funds coming in from friends or family, all these transactions, especially if they're at the very end, close to when you're filing your EB-5 petition, they will be looked at. Okay, and so I think it behooves a potential investor to consider opening a separate savings account, especially if you have a very active checking account, in order to preserve, sort of the corpus of funds that's being used for EB-5. Now, again, if you've transferred yourself more than enough money to cover your investment from your brokerage account, and you have small withdrawals to pay off your credit card, you have salary deposits coming in, small withdrawals and deposits likely aren't going to be an issue. Okay, but the larger deposits that don't have a source that we haven't identified, those will very likely be flagged by USCIS. So again, we want to flag those as best as possible early on. Okay. And again, if you've used funds that we've already sourced after they've been deposited in your account, we want to confirm what you've done with them before you've invested them for EB-5.
Perfect. Okay, so that's a really great summary of ordinary income. Now, probably the second most commonly used source is capital gains. So let's jump into this and start with real property.
Yeah, absolutely. So, especially given the current market, I think if you bought a home or if you purchased a significant asset, in the last 5 to 10 years, it's probably appreciated. I hope it has. I generally speaking, I say 50% of my current clients are looking at using either their primary residence or an investment property as collateral for some type of loan or some type of line of credit. Again, very, very common. When you're thinking about real property, the first thing the government is going to look for is, do you own it? How did you acquire it? Okay, and so that may be quite simple. If you purchased your property in the last 5 to 10 years and you did so using a mortgage loan and your down payment came from your earned income. Okay, in that case, we'd want to document your purchase of the property, the mortgage loan you used, whether that was paid off, and as best as possible where the down payment came from. Typically, it's going to have come from your bank account, and it may be earned income. It may be you sold stock, RSUs, perhaps you were gifted funds from family, which is incredibly common. If that's the case, that's sort of an extra wrinkle that we'll want to try to develop as best as possible, whether that's reaching out to the family or friend and confirming, generally speaking, where the funds came from, what documents we have to support it. Normally, I'll have a friend or family member who provided down payment funds draft a simple affidavit saying, hey, the $20,000 I gifted to my brother to purchase his funds came from my earned income. Here are my tax returns for that period of time, and here are my bank statements and pay slips. If we're talking about real property that was purchased a long time ago and only recently sold, then we normally, it's normally a sort of a two-tiered approach where we'll have subjective documents from the investor, such as a declaration, a sworn affidavit confirming what he did back in that time that allowed him to purchase the property. Okay, and then any type of objective document, whether it's old pay stubs, old tax returns, old property purchase documents that we have that are available, that we can include to corroborate that declaration. Finally, one more thing I'd mention is if documents aren't available due to the passage of time, if your bank only keeps records for 10 years, we'll want to confirm that beforehand before the government asks why we haven't included them. Most banks will have information on their website. You may even have a branch manager that can attest to the fact that we just don't keep records that long. And then if you sell property, okay, if we're not using, I guess I've sort of delved into the loan process here too, but if you're selling property, we need to confirm the sale, the sale transaction documents, valuation of the property, and right at the end, the transfer of sale proceeds to the individual's bank account. And again, if you've done anything with those sales proceeds since you obtained them, okay? So if you invested them, if you purchased another property and then sold another property, we'll have a few layers to unravel. The sale of a company in some ways is similar. We have to go back to when the company was formed, okay? And so much like the sale of a real estate asset, the government will want to know that you own the company, whether it's 100% or whether you own 10 to 20, what your ownership share is. The government has the right to ask, how did you buy in? What was your initial investment? Was it was this a company you started with a friend, with sweat equity and you didn't invest any significant capital into? Or was there a larger buy-in of, perhaps $100,000 to fund the company and to get things started? If it was the latter, we'll want to document how you invested and where those funds came from, again, as best as possible. If this is a recent occurrence, then documents should be readily available. If this was a company that, you started 20, 30 years ago, or your father started 40, 50 years ago, and then gifted shares to you, then that's a different scenario, and in which we'll want to have a good affidavit and any other documents that can corroborate that affidavit. Again, in terms of the sale of a company, I think it's fair. I think the government's always going to want to see tax documents, financial documentation to confirm the lawful operation of the company. Okay, so I agree with 7 years. I think that if the company's been around that long, 7 years makes a lot of sense, just because that's what the government wants to see for individuals at this point. And so again, that's just proving the company operates lawfully. Whether you have audited statements or not, but for sure tax returns are going to be relevant. And then finally, again, those documents that prove the sale, the sale transaction documents, and then the deposit of sale proceeds into the individual's bank account. And again, if something's happened after that fact, we need to document that as best as possible. Even looking at the FAQs below, which I think are very relevant. I always tell my clients we need to do as best as we can, right? And my clients say, how far back do we need to go? And I say, well, we need to go as far back as we can. And I say that because every adjudicator is different. Sometimes you'll have an adjudicator that won't raise questions that other adjudicators will. And again, it's an individual reviewing your case. The law says one thing, but the application of current regulations by an individual adjudicator is a very different thing. So, if you had cash transactions in the past, obviously there may not be a ledger, there may not be a record, but we need a good affidavit that says this is how transactions occurred during this period of time. This is what happened. If there were other individuals that were involved in the transaction, having them provide a short statement is incredibly helpful, okay, because it corroborates what you're saying. And generally speaking, I'd rather provide more specific evidence that corroborates one another than not. I'd rather provide as much as we can, assuming it's legitimate evidence that's straightforward and concise, than wait for the government to issue a request for evidence that may be much more difficult to answer years later.
All right, great. Let's jump into some of the common issues that you see come up.
Yeah, again, translations, you need them. Whether it's a sale agreement, whether it's the valuation of a real estate asset, sometimes, again, if it's very common in India, for example, you have very, very long sales deeds, hundreds of pages. A lot of the times I'll have my client and or his or her financial advisor or CPA point out the specific pages that we need to look at. Okay, I've done that many, many times and it hasn't been an issue. Every once in a while the government may ask for the full document, but if it's some of these deeds are 200-300 pages long, I think you can be very specific with the pages you include. But at the end of the day, the safest thing to do is to provide full translations. Okay. Payment of taxes, the same issue. Tax regimes are very different around the world. Rather complicated here in the U.S., but the USCIS knows that cap gains have to be paid on on sale of most assets, and unless specific exceptions apply. So again, if you're selling a home, if you're selling any other type of hard asset or security, the government will want to know that taxes have been paid. Okay, generally speaking, your full annual tax return should confirm that, but that may not always be the case depending on where the asset was sold. Okay, it's a great point. The government does look at bank statements. So again, if you were served, if you obtained X amount of funds net tax, they're going to look at the bank statements and want to confirm that same number that may be referenced elsewhere on a specific tax document or certificate. Okay, and again, tracing. I touched on this in the previous slide, but it's very common. We don't normally let money sit, right? So if you've sold something, it's likely that you've used the proceeds and rolled them into another investment, into another real estate asset, et cetera, et cetera. So again, we always work backwards in terms of source of funds and in terms of documenting the sale of assets, but we need to trace funds. So if funds were deposited in your account from the sale of a property in 2022, and you put all those funds in your Vanguard account, we need to document that specific series of events. Okay, and obviously, if you're using the Vanguard funds later on, we'll simply document the sale of securities for your EB-5 petition. Okay. Again, commingling, small deposits, small withdrawals here and there, especially if the amount of funds deposited is more than enough for EB-5 petition, not as big a deal as larger incoming deposits that are untraced. Again, isolating EB-5 funds early is always recommended, and opening up a separate savings account is generally the way to do it. I think we've touched on most of these FAQs. Every case is a little different. For most of my my clients will have some type of source of funds declaration that walks the adjudicator through all the source of funds generally, and I think that's really helpful, especially for cases that may go back some time or that may involve funds that have from assets that were purchased a long time ago.
All right, let's jump into gifts and inheritance. This is also a really common source. Probably not as big as the loans or ordinary income, but it's still one that comes up quite often.
Yep, it's common. I think inheritance is something that we see frequently. When you're talking about inheritance, you always need probate documents. So you need a will. If you don't have a will, you need to sort of confirm why, and or typically, if there's a probate attorney that worked on the case, so to speak, he or she will be able to provide information in terms of how intestate succession works in that specific country, and or how and why property and or assets or cash passed down to the specific person. When you're looking at funds or inherited land, for example, it's very common in India especially in certain provinces, to have land and or property passed through multiple generations. We always want to confirm ownership. Typically, those documents do exist. Typically, they have to be translated, which is okay. Sometimes, obviously, certain individuals may not be able to provide declarations, but other family members can. And so if the funds are coming from inherited property from grandpa and grandma who have passed away, we'll have the investor and or mother or father provide a declaration that confirms what that individual did to acquire the property, what they did for a living, when it was acquired, the specific details concerning the acquisition as best as possible. And then again, more objective documents confirming ownership, of inherited property or assets, and then very specific documentation to confirm the final sale of those assets, for example, or the specific passing of assets to the EB-5 investor. Okay. Most of these cases are going to, include a detailed declaration that, could be anywhere from 2 to 10 pages long, depending on the path of succession and or what's happened to the land since it was first purchased. It's very common for land to pass through, the hands of multiple family members before it's sold, and funds are made available for the EB-5 investor. So these cases tend to take a little bit more time to document, but a good declaration is the best place to start, and then we sort of build on that with other objective evidence, that's available. I've done a lot of these cases successfully. I can't stress how helpful a detailed declaration is that, again, can be corroborated by other objective documentation. It's definitely the way to go.
All right, let's jump into some of the common issues that you see come up there too.
Yeah, translations can be an issue with documents that are very old. The quality may be poor, and again, I think that's where relying on family friends back home who may have access to local translators. I tend to think that helps significantly. Again, certain pages of certain documents may not be relevant, and so focusing on the pages that confirm ownership, that confirm specific biographic details and or names and when transactions occurred is really important. In the case of most inherit, you're almost always going to have translation requirements when funds are inherited abroad. Payment of taxes, again, it's always going to be an issue when an asset's sold abroad. And again, most of the time, the transactions are occurring relatively frequently. I have a lot of clients who have family abroad that have inherited property, who have sold the property, quite frequently, and they're able to provide documentation confirming ownership and confirming the sale, and provide a detailed affidavit, confirming the source and the path of those specific funds. When you have family and friends involved, I tend to say, I don't mind it at all, because family and friends want to help you, right? They're going to, unlike a big bank, for example, that's going to have very strict procedural rules, family and friends are going to want to try to provide what documents they can, generally speaking, to help you out with your case. That's not always the case, but that tends to be what I see. And so, again, sometimes it's more difficult because you can't control exactly what your family or friend has done with funds they're gifting you. And so, again, if you have multiple family members or friends that could potentially gift you funds, what I'll say is, try to choose what we'll want to investigate in terms of what will be the path of least resistance. And what I mean by that is where documentation is going to be more plentiful, where documentation is going to be more recent, more clear, and more convincing. Okay, if someone's inherited property and sold it, and then the money's gone 18 different directions after they receive the proceeds, and then the money's come back, that's going to be pretty difficult to document. We can do it, but there may be a simpler route. Okay, so again, commingling and or the use of funds after they're acquired before they go to the EB-5 investor is always going to be a relevant issue. So again, a lot of commonalities there in terms of funds that are coming from family and friends are going to be similar to funds that have come directly to you, for example, from your employer.
Perfect. All right, and to round things out, let's spend a few minutes on the last major source, which is loans.
Yep. Most of my clients use a variety of loans. I think it's, unless you've saved a lot, sometimes it may make more sense to take out a loan, so you don't have to, break a CD, so you don't have to sell at an opportune time, so to speak. If you're using a personal loan, there's a lot of financial institutions out there now that do direct lending. Those are going to be similar to banks in the sense that it's very unlikely that USCS is going to ask for documents concerning how a bank operates and or how a large lending company operates. If it's a very small lending company, for example, one that doesn't have a website, one that may or may not be accredited, I'd probably try to stay away from those, only because the government can only ask to confirm that a small lending company is operating lawfully. But if it's an established lending company that has relevant licenses, that's been in business for a long time, typically those are treated more like banks. Okay, and in those situations, if you take out a personal loan from a bank or a lending company, the government's going to want to see the loan document. They're going to want to confirm that there's no restrictions on the use of the loan. So, for example, if you take out a margin loan or a loan backed by securities, there may be very significant restrictions on how you can use those funds. Typically, they're not going to have restrictions on a private placement like an EB-5 investment, but you have to be very careful. So you have to look at and you need to be very straightforward with your lender, before you borrow money. So typically, I'll have my clients send me loan documents before they finalize to make sure that the loan doesn't have clauses that could be troublesome. And again, the deposit of loan proceeds into the investor's bank account is very straightforward. Again, if the loan is collateralized, which used to be a requirement pre the Zhang decision, the government can ask, how did you obtain the assets that are collateralizing the loan? Okay. And so again, I think I did discuss HELOCs, for example, or lines of credit secured by real property. The government's going to want to know how you came to come across, how you purchased that property in the past, where the down payment came from, whether the mortgage loan is paid off or not. Okay, and so, ideally in today's world, an unsecured loan that's a legitimate unsecured loan, whether it's being guaranteed simply by you or even guaranteed by friends or family, which is also fine, you don't have a collateral issue. But again, collateralized loans are very common, especially in terms of property. And we're going to want to confirm how the underlying asset that's collateralizing the loan was obtained, and how it was paid for, and to confirm ownership. I think when you're looking at it, we can sort of jump to the second little bar here. Source of funds for a lender is a unique issue. I think it typically comes up if you own your own company, for example, you're a shareholder of a small closed entity that's loaning you funds, perhaps like a shareholder loan, for example. A few things there. We need to confirm that it's a valid loan. Depending on the bylaws or the operating agreement of the company, loans could be an issue, right? When are you allowed to take out a loan? Who has the ability to do so? Do you need collateral? Is the loan collateralized by your shares in the company? Okay. Generally speaking, if you're borrowing from a company or you're taking a shareholder loan, we need to confirm your ownership. We need to confirm how you obtain that ownership, and we need to confirm that it's a valid loan. So we need a loan document. Okay. And typically tax returns and financial documents to confirm that the company is legally operating, and bank statements to confirm that the funds are actually coming from the company's bank account. Okay. It's a very common source of funds. It's easy to document in terms of there are very specific documents that USCIS is going to want to see. But again, with closely held companies, you can always have issues with other investors and other owners. So again, definitely a case-by-case basis. And again, collateral is an issue with loans. It always has been. It's not anymore in the sense that you can have an unsecured loan that's not collateralized, which is much more straightforward. But if your loan that you're using, the proceeds of which are secured by an asset, we're going to have to look at the collateral. And again, the loan document itself is also going to be important.
All right, got it. And then let's wrap up this part of the presentation and just some of the common problems that you see with loans.
Yeah, I think with larger companies, it's making sure that that there's no restrictions on the use of funds. Some large lenders may have very specific uses of those loans. The government will 100% review the loan document. If there's any taxes that had to be paid when you borrowed money or due to the collateral involved securing the loan, those tax documents are going to be relevant. Again, translation, again, any type of loan agreement, I'd recommend translating the entire document. That, unlike other large documents, the government will want to make sure that every clause in a loan document is translated. And then finally, when loan proceeds are deposited in your account, did you do anything with them before you invested, for your EB-5 petition? Commingling of funds, never the best if there are, if there's a lot of commingling going on. And so again, if you control the loan, if it's a HELOC or if it's a shareholder loan, I would deposit those proceeds into a separate account that's only going to be used for your EB-5 investment. And that way we sort of have we have a closed box in terms of documentation and in terms of minimizing or eliminating commingling.
All right, and so let's zoom out a little bit and just talk about how does all of this information, loan, gift, ordinary income, how does this information get kind of nicely organized, assembled, and then presented to USCIS? And how do you as the immigration attorney work with the client to put everything together?
Yeah, that's a good question. So, normally if, whenever when we onboard a new client, we'll discuss source of funds in detail. We'll provide a detailed source of funds checklist that will sort of walk the investor through the specific documents we're going to need for the specific sources of funds. So if it's just earned income and stocks and RSUs, that'll be a simple source of funds checklist. If it involves inherited property, if it involves a mortgage loan, if it involves a few other sources, it's going to be a larger document. We'll have a document Dropbox to upload documents securely in an organized fashion. And, generally speaking, on my end, I prepare a very detailed exhibit list and a very detailed attorney memo that walks the adjudicator through the documents we're submitting, through the path of funds. It corroborates and sort of explains the investor's declaration. Depending on the source of funds, we may use charts, we may use some graphs, and we'll have a detailed exhibit list that walks the adjudicator through the different sources. Okay, and so we won't have everything sort of smushed together. We'll take every source individually. We'll have a different section in the exhibit list and in the attorney letter that goes through those specific sources. And then typically what I like to do at the end of my attorney memo is have a very detailed path of funds, sort of A through Z, that walks the adjudicator through the final transactions that resulted in the final wire going out to the regional center. So again, we're sort of working backwards. And so again, that final set of transactions could be one transaction if you got a large bonus from your employer, or it could be 20 transactions if you've had funds gifted to you, if you've had funds loaned to you, and you've sort of accumulated and pooled funds from various sources. I tend to think a really good exhibit list writes the attorney letter, and a really good declaration helps writes the attorney letter. A good declaration is primary evidence the government has to consider. My firm's attorney memo is an argument. It's a helpful argument that walks the adjudicator through the evidence, but a declaration is really important too. And I think nowadays I try to be as concise as possible. I try to be very straightforward with presentation. I do think less is more in certain circumstances. Again, if we're tracking evidence over 10 years, I don't think we need 120 bank statements to simply prove the accumulation of saved income, where a pattern argument may be much more simpler to understand as long as there's no large deposits, coming into that account in the interim. Okay, but a really good, you want to make sure your attorney, has a detailed exhibit list, points out the nuances of specific documents, names of companies, dates, and what that document proves. Again, if a document isn't proving anything important, if it's not part of the narrative, it shouldn't be in there. It's, again, these adjudicators don't have all the time in the world to review these cases, so I'd much rather have a case that's accurate and detailed, but but isn't a few thousand pages. I think that can often slow down adjudications.
Okay. All right, that's a really good summary about the different sources of funds that primarily come up and also how they're laid out. Let's shift gears for a minute, and I'll just quickly provide some comments on some of our currently available EB-5 projects at the $800,000 level, and then follow up with a few questions from Dennis. So currently we have 3 different EB-5 projects open. We're adding projects every month or two, so this list will always be changing, and the best place to go is to our website, eb5investments.com, to get an idea of what we currently have open and have space in. But first, on the rural side, our Twin Lakes, Georgia project with the Coulter Group, one of the largest home developments in Georgia, with 1,300 homes. About half of them already sold. The project's already profitable. Thousands of jobs already created. Coulter's done over 20 EB-5 projects with us over the last more than 10 years, 100% success rate. This particular project is in a rural area outside of Atlanta, and we do have space in the current loan vehicle for that project. And then on the urban side, another project by Coulter in South Florida in Boynton Beach, which is in an urban area. So same $800,000 investment amount, but no priority processing. And in that project, we have both an equity option with a higher 5% return and also a debt option with a lower return, but increased capital safety. So we didn't really touch on the differences between rural and urban at all in today's presentation. So Dennis, do you want to kind of give us the quick overview on what is rural versus urban? Why does that matter now under the RIA? And what are you seeing your clients, in terms of preference of selection and also country of origin? How does that kind of factor into the rural versus urban decision?
Yeah, that's a great question. I was actually going to suggest we bring it up since it's so important. So the RIA created additional visa set-asides, or in a different way of thinking of it, it's carving up the available visa quota for EB-5 into different categories. And the most important of which are high unemployment, which is 10% of the quota, rural, which is 20% of the annual quota, and then there's 2% which goes to infrastructure projects, which I'll ignore for the time being simply because we don't have policy and or regulations that really determine exactly what that is. And generally speaking, the projects that are available that are being sponsored by a regional center nowadays are going to be rural or high unemployment. So generally speaking, a TEA, a targeted employment area, is either a rural area or a high unemployment area. In the monthly visa bulletin, there are now specific carve-outs. So there are specific numerical carve-outs for high unemployment green cards, for new EB-5 investors post RIA, and for individuals investing in a rural project. Okay, looking at rural first, the significant benefit. Well, there's a few significant benefits for rural in terms of an immigration perspective. Okay, setting aside the merits and the specific risks and benefits of a project, USCIS has to prioritize the processing of rural projects, meaning I-526E petitions filed in a rural project over high unemployment projects. This is specifically from language in the RIA. In practice, we are seeing I-526E petitions that are filed in rural projects where the project documents have already been approved. Again, every regional center has to file an I-956F application to approve a specific project. Once that project is approved, typically what we see is that the individual I-526E petitions are adjudicated in batches for that specific project, 2 to 3 months after the I-956F approval. Okay, so there's an inherent benefit in investing in, a project that has a rural designation, that may even have the project approval. And again, I say benefit from an immigration perspective, from a quicker processing perspective. Okay. Second, there's twice as many available green cards per year for the rural category. Okay, it's a 20% set aside versus 10%. Okay, at this point, and based on Department of State's comments at immigration seminars in the last month, the visa bulletin is going to stay current this year and possibly all of next fiscal year for both categories. Okay, so two things. That's great for any individual who wants to file an I-485 application concurrently with their I-526E petition, whether that's in a rural area or a high unemployment area. Okay. The issue in terms of green card issuance, which again comes up very frequently in in chat groups and other seminars and conferences, is will investing in a rural project versus an urban project speed up the issuance of my green card? And that's sort of a multi-layered question, because again, you need a project approval first, you need your I-526E to be approved, you need your I-485 to get adjudicated, and then we look to the visa bulletin to confirm if your specific category based on your country of origin is current. Okay, a lot of the data suggests that when a wait list, when we have a cutoff date, it'll likely impact the high unemployment category first, based on data from the Department of State and based on data from USCIS that was FOIA'd in terms of how many people are investing in high unemployment areas versus rural. I think, in the current market, there's a lot more rural projects now than there were a year ago. The data we have from USCIS that was FOIA'd stops at a certain point, so that it's very likely more rural applications have been filed in the last year than the year before that. That being said, it's very difficult to predict what the cutoff date is going to be and exactly how many petitions have been and will be adjudicated in the future. There's a lot that goes in to determining this, from people dropping out, cases being denied, families changing in terms of their composition. But I think what you're seeing now is most people, most clients are hoping for a good rural project that has a project approval. Obviously, from an immigration perspective, that offers the potential benefits of a quicker adjudication. I'd also say it's really important to mention that the issuance of your EAD and your advanced parole document doesn't depend on whether you invested in a high unemployment area or whether you invested in a rural area. Those are adjudicated. Those are ancillary benefits that are adjudicated based on service center processing speeds that aren't involved directly with the I-526 petition. And so, again, as an immigration attorney, I don't provide financial advice, but I look at the visa bulletin and these, and the visa issuance, I think, is very important from an immigration risk perspective. And so, that being said, both categories are current. They're likely to remain current for the foreseeable future, at least into the next fiscal year. But it's an important topic to discuss with your attorney and any other advisors you have in terms of what project is the right fit for you and what you can expect from an immigration perspective.
Perfect. Thank you, Dennis. One thing I want to point out there too is that, for the urban projects, for investors from the higher volume countries like China and India, it may be a lot longer to get the green card in those projects, given that a lot of investors have already invested in those projects and are already in line. However, like Dennis pointed out, if you are in the US already, you can get that work and travel permit in about 90 days, and it's valid for 5 years. So that gives you a lot of the employment and travel flexibility, very quickly. And so a lot of our domestic investors on H-1B and F-1, they're comfortable, facing a potential delay to get the green card due to a future backlog in that category, because they are going to get that work and travel permit for all family members very quickly. And so that gives them a lot of the benefit from what they're looking for with the EB-5 investment in general. So that is important to note. All right, and Dennis, for investors, who are interested in getting in touch with you and, chatting about a potential EB-5 application, can you talk a little bit about kind of what your intake process looks like and how you can, do an initial call with someone and kind of walk through what their proposed source is, what documents, may be needed, and just kind of what that process looks like working with you and your team, and roughly how long it takes to get someone in a position where they're ready to select a project, once they decide to start?
Yeah, happy to. So we're always taking on new clients. It's a busy time, which is exciting. Email's a great way to start a conversation with me. You can go on the Tristani Law website and fill out a contact information form as well. In your email, you can always provide relevant details concerning your family size, concerning source of funds. Happy to schedule, a free initial call to go over potential source of funds avenues, to just discuss your case, your family, and what you're looking to do. That's something that I offer to all potential EB-5 clients. In terms of intake, again, once we move forward with the engagement process, it's going to be, sort of a two-tiered path. It's a lot of my clients will engage my firm when they know they want to do EB-5, or they're strongly considering it. They're looking at a few projects, they're having conversations with regional centers, and in parallel to doing that, they want to get started on source of funds, they want to get started with form preparation. And so again, intake is going to be an initial call. It's going to be a source of funds document checklist, a secure Dropbox to start uploading documents. A lot of my clients like having a secure WhatsApp group, to just for quick questions and let me know what's going on, or let me know the documents have been uploaded. And then typically speaking, 3 to 6 weeks is pretty common in terms of start to finish putting a case together. We've done it in a week. When we've had filing deadlines, there's never a rush on my end. But we have a good team. We're very efficient. And so, if most of my clients that are looking, to file this summer, for example, we're able to do so in 2 to 4 weeks, which is a pretty common turnaround time, depending on source of funds complexity and in terms of, how long it takes to select a project.
Perfect. Thank you, Dennis. All right, so I think that's where we'll wrap up for today. So any questions related to any of the projects we talked about, or projects in general, please reach out to EB-5AN. You can check out our website, book a call, reach out to me. That's my number, on text, WhatsApp, etc. And then Dennis's contact details are below there. And any immigration related questions or anything source of funds related, please reach out directly to Dennis. He's the expert on all of those matters.